Well, welcome back, everyone. So we've heard a lot about how the repair debate is playing out in the United States, but repair, of course, is an issue with global implications. So we've assembled a panel of international experts to give us a better perspective on how issues related to repair are playing out in other jurisdictions. We've got a lot of ground to cover here, so let me briefly introduce our panelists before we hear from each of them in turn. Matthew Rimmer is professor in intellectual property and innovation law at Queensland University of Technology in Australia. Estelle Derclay is professor of intellectual property law at the University of Nottingham in the UK. Jessica Richter is Associate Senior Lecturer at Lund University in Sweden. And finally, Anthony Rossborough is a doctoral researcher at the European University Institute, as well as the co-founder of Can Repair, the Canadian Repair Coalition. So we are going to begin with the Australian perspective with Matthew, who is kind enough to record some remarks for us. So why don't we start by rolling that recording now?
My name is Matthew Rimmer. I have really become interested in the right to repair out of a series of different research interests. So I've been doing a lot of work on intellectual property and climate change over the past decade. I've been very interested in intellectual property and sustainable development. I've also been doing a lot of work around intellectual property and 3D printing, in which the right to repair is a kind of an important issue across all those disparate fields. I'm a professor of intellectual property and innovation law at the QT Faculty of Business and Law in Australia. And I will really be telling the story of the Australian fight for the right to repair. As is always the case in Australia, I'd like to acknowledge the Turrbal and the Yugara as the First Nations owners of the lands where QT now stands. And I would also note that there's a kind of an ongoing struggle in Australia and internationally to try to get greater recognition of Indigenous intellectual property. In Australia, the right to repair is a very critical issue for many Indigenous communities in rural and regional Australia. To begin with, I'd like to give you a quick sense of some of the politics in Australia of the debate over the right to repair. Historically, as a British colony, Australia was very much dependent upon supplies of goods from the United Kingdom. So as a result of those difficulties in terms of gaining supplies, there was quite a thriving local culture of repair in colonial Australia. After Australia's independence, Australia became much more dependent upon mass-marketed imports from overseas. But the topic has really kind of come to the fore over the last few years in Australia. And we're kind of grateful that the ACT Attorney General Shane Rattenbury, a member of the Australian Greens, has been a great champion of the right to repair. He has pushed for his fellow territory, state and federal ministers to support an inquiry into the right to repair, but also to try to push some law reform in relation to consumer law, competition policy, questions around intellectual property, as well as kind of taking some larger action in relation to sustainable development and climate action. And this has been a really important contribution because Australia does not necessarily have the same well-organised civil society groups working on the right to repair like in the United States or in the European Union. Surprisingly for Australia, there has been some very kind of important kind of consensus between the major parties on this issue. So the Australian Labor Party, who are the federal main opposition party, have been interested in the right to repair, particularly in the context of motor vehicles and the need for independent repairers to kind of gain access to repair information. So Andrew Lee has been kind of quite vocal in that regard. Of the ruling coalition parties, the National Party in Western Australia have been very keen on there being action in relation to the right to repair to deal with agricultural machinery. So as a result, the Liberal Party, who are part of the kind of conservative coalition at the moment in power in Australia, agreed to a reference to the Productivity Commission to investigate the topic of the right to repair. Given that an election at a federal level is imminent in Australia, it will really be left to the next parliament to determine what, if anything, happens in terms of some of the recommendations that have been flowing from the Productivity Commission. So I just want to give a quick overview of the Productivity Commission inquiry and then look at some of the elements of the inquiry dealing with intellectual property, consumer law and competition policy, e-waste and product stewardship. And I'll wrap up saying a little bit about innovation law and policy, comparative developments and international law. The Productivity Commission is a kind of an independent body in Australia that carries out empirical economic research to better inform law reform in Australia. It's kind of played a really kind of critical role as a catalyst for law reform in lots of various areas. They had a very good process in which they kind of went through an issues paper, a discussion paper, and a final report. The final report is open access. It is a good 384 pages long. I would highly recommend that you download it and have a look and read some of its insights. In terms of a kind of a broad brush approach to the key recommendations, the Productivity Commission has called for an enhancement of consumer rights, a promotion of competition, an enablement of access to repair supplies, and an improvement of product information, e-waste management. In my kind of submissions to the inquiry, I was kind of pushing for some slightly bolder recommendations, but I'll kind of talk about that as we kind of go through the recommendations one by one. In terms of intellectual property and sustainable development, the Productivity Commission were very focused upon copyright law. And in terms of their kind of key recommendations, they recommended that there should be law reform in relation to copyright law. They recommended that Australia should amend the Copyright Act to include an exception that allows for the reproduction sharing of repair information. In the medium to long term, it recommended that the Australian government should pursue a more flexible copyright exception regime, including a principle-based fair use exception. They called for amendments to the technological protection measures regime, and they also called for prohibitions on contracting out of copyright exceptions. I would note, though, that really the right to repair is a combination problem that cuts across a wide array of different forms of intellectual property. And I kind of argue that it would have been better for the Productivity Commission to make similar reforms across the different disciplines of intellectual property. In relation to designs law, there is an explicit spare parts exception under Australian law, and that has been recently tested in a case involving customising cars, which is kind of a great Australian hobby. And that spare parts defence was successfully used in that case. However, the provision is really quite convoluted and complex and is increasingly looking a little bit outdated. We would benefit from a more general defence in relation to designs law dealing with the right to repair. In respect of trademark law, the Productivity Commission did not make any kind of recommendations for law reform. In my submission, I kind of pointed out that Apple had kind of taken action against an independent repairer in Norway, and that there was a similar risk of something similar happening in Australia, but they didn't make recommendations in that particular field. In respect of patent law, the High Court of Australia has handed down an important decision recently dealing with patent exhaustion in the context of refurbishment of printer cartridges. So strictly speaking, not exactly a repair case, given that was dealing with refurbishment rather than repair. The Productivity Commission were of the view that the ruling on patent exhaustion had a more general application in relation to the repair of patent inventions. I would argue that the High Court decision does not necessarily lay down very bright lines about what sorts of repairs are permissible and what sorts of repairs are not. So I think that area would also benefit from some sort of explicit defence. In relation to trade secrets law, there was a little bit of discussion about the impact of trade secrets upon repair, but unfortunately there wasn't really much in the way of law reform recommendations. I think that's quite a big issue, particularly given that Australia has expanded its regime for trade secrets. There's also a bit of discussion around data and information as well. So there's a special treasury scheme in Australia about repair information for motor vehicles. There was a bit of discussion about whether or not there should be similar requirements and obligations in relation to other sectors and fields. So that was the key set of recommendations in relation to intellectual property. In respect of consumer law and competition policy, the Productivity Commission did acknowledge that the Australian Competition and Consumer Commission had taken some action in the past, particularly under consumer law, against companies. In particular, there had been action taken against Apple. In their report, they expressed concern that consumers sometimes lack the ability to exercise their existing rights to obtain remedies for defective products through consumer guarantees. So the Productivity Commission called for a super complaints process, enhanced dispute resolution powers, enhanced regulator powers to enforce guarantees. They also wanted to require software updates for a reasonable period. There was also some discussion of competition in repair markets. They found in the Productivity Commission report that there was no evidence of a systematic competition problem across all repair markets. They did identify, though, that there were some markets that seemed to have some problematic issues around competition. Just note in relation to EWaste and product stewardship, there are an array of fab labs, repair cafes, and social enterprises that raise concerns about product obsolescence and the explosion of e-waste. And there were some international organisations as well who also joined in that debate, like the redoubtable iFixit. The Productivity Commission, though, only grudgingly conceded that e-waste was a small but growing waste stream. They argued that the evidence on premature obsolescence was mixed. They were of the view that interventionist responses to premature obsolescence were not needed, and that there was a need to provide better consumer information and develop and introduce a product labelling scheme like France. In some ways, I think that the Productivity Commission perhaps could have had some stronger recommendations in relation to some of the environmental dimensions of the right to repair. I think another kind of really important issue from an Australian context is boosting innovation in respect of sustainable production and consumption. Some jurisdictions like New South Wales have set up circular economy innovation networks. There's been very creative researchers like Professor Veena Sarawala, who has been doing really interesting work on the use of waste materials. Australia, though, seems to be lagging behind some other jurisdictions when it comes to sustainable innovation. So really, we need to boost the circular economy in Australia. The Productivity Commission report also draws upon developments in the United States and Canada, which you'll be hearing about at this conference, as well as in the United Kingdom, the European Union, and South Africa as well. And hopefully that will help encourage Australian legislators to kind of take action in relation to the right to repair. But really, I think what this conference is showing that there's a kind of a larger international movement for there to be recognition of the right to repair. It's notable that the United Nations Development Programme has been setting up a network of accelerator labs to help realise some of the Sustainable Development Goals, including Sustainable Development Goal number 12, relating to responsible consumption and production. I think it's kind of critically important that we try to push for a greater international recognition of the right to repair in that context. Just to wrap up, I would note that even in a galaxy far, far away, the right to repair is a critically important issue. In the Star Wars trilogies, it's a coalition of hackers, scavengers, and junkers who take down the evil empire and the First Order. I think in relation to the debate over the right to repair, we need a similar broad-based alliance to make the right to repair a reality. Thank you very much for your time and attention. It's been a pleasure to join this event.
Well, that was wonderful. Now that we have a better sense of the Australian landscape, I want to turn things over to Estelle to discuss how the intersection of law and repair plays out in the EU.
Thank you very much, Aaron. I hope you can hear me and see my slides. Yep, yes. Great. So I'll just do this gist. Share it in the better view. Yeah, that's it. So thank you very much first to Pamela for inviting me to talk today, and obviously to Aaron for organizing all the details of this panel. And yes, I've been tasked to talk about the right to repair in the EU, which is a huge topic, of course, because as you can imagine, it involves plenty of provisions like Matthew Rimmer was just discussing in Australia. So it's a bit of a challenge, but I will try to cover most of them. And with the caveat that I'm an intellectual property lawyer, I'm not a competition lawyer, environmental lawyer, or consumer protection lawyer, but I will give you the main provisions that apply so that you can have an overview of what's the situation in the EU. And then I think at the end, I'll just have one slide on further ideas beyond that. You know, what else can we do with the law, especially with IP law in that regard. So first of all, what are the intellectual property provisions, starting with copyright? Well, there's not much, but there is an article which is really important, which is the hook for the right to repair in copyright law in the EU. Unfortunately, it's Article 5.3L of the Information Society Directive. It's optional, so member states don't have to include it in their law, and not many have done so. And as far as I know, there's very little, if any, case law at national level, and there's no case law from the Court of Justice on it. So that's a general exception for to use a copyright work in connection with the demonstration or repair of equipment. Now, the most interesting development come in relation to software, and I don't have the time to discuss in detail the top system decision, but if people want to ask me questions in the Q&A, I'll be very happy to develop that. There's an Article 5.1 in the software directive, which enables people to access the software for normal use and to correct errors. So I call it the debug exception, right? And that exception is mandatory, so every member state has to have it, and it's imperative. You can't contract out of it. So, you know, Microsoft or other Apple, whatever, cannot have a contract, license, adhesion, or whatever telling you, no, you don't have that right. And in top system, the Court of Justice, so it's very important because it's a Court of Justice decision, so it applies all over the EU, said that you have the right even to decompile the software to correct the error, with the caveat that there can be a contract which in some ways take away that right, but then obliges the manufacturers to give you that code so that you correct the exception. I'm really generalizing and summarizing the decision a lot. There's lots of nuances, but it's overall a very good decision. Then there is the Data Act regulation proposal, and that's not directly in the field of copyright, but it can impact it. This has not been adopted. It's just been proposed by the European Commission, as you can see, very early this year. And in there, I mean, just to tell you what the Data Act is about, this is a big thing in the EU and everybody's talking about it right now. It enables people to basically share the information that is generated by Internet of Things products. So basically all the data that's non-personal, so data that doesn't concern your privacy, but data that is generated by any IoT product, that data, the user can access it and can give it to a third party or can reuse it, basically without much, there's nothing that can be prevented. And obviously that's great because that could help repair and you don't have to rely on a manufacturer. So we'll see what happens to that. It may change a lot because there's probably going to be lots of lobbying, but it's something to watch. And it's very important because in the EU, we have, as you may know, the database sui generis right, which protects to some extent some data. Again, I can take questions at the break on this if people have questions. Now, in patent law, there's not much. As you may know, patent laws are not harmonized at EU level. There's the European Patent Convention, but that's an international agreement that covers far more than just the EU. And there's nothing. So what there is only Article 5 of the Paris Convention, and it's in most member states' patent laws, but it's very limited because obviously that only enables repairs for aircrafts and vessels and the like that cross temporarily the member states' airspace or territory. And that means it's not an infringement of the patent if you repair, but that's it really. So there's not much. Now in the UK, so you got to look at national law for that. And in the UK, we have a House of Lords decision from 2001 in United Wire that has explained the notion of repair. And it has said that repair and making, so making the product being an infringement of the patent, are mutually exclusive. So repair an article is not making, and therefore it's not an infringement. But obviously, if the repair is so extensive as you making it anew completely, then that would be not possible to, you would be infringing. It's not within the exception anymore. Most extensive application of the sort of repair in the EU in the IP field are in designs and in trademarks. Why? Because in designs, and that's very important, all the interconnection parts, so that the must fit part of a product, much match. That's if, for example, take a car, you cannot put the roof of a Volkswagen on a Porsche or vice versa. It must match. All this is not protectable by design law. Purely functional designs are not protectable either. In UK UDR, we call that methods of construction. All this you need to ask for a patent. So you can't have a design on that. And obviously, if you can't get a patent, it's also not protected by IP. And that's both in registered and unregistered design rights, because we have both at EU level and also in the UK unregistered design right. And that's just for reference. I've given you the articles of the design directive here, but it's also in the design regulation at EU level. And then component parts of complex products which are not visible during normal use are not protectable by designs either. So think of anything that's inside a car that you need to disassemble the car, like an exhaust pipe or some part of an engine, not possible to protect it by designs. Trademarks, purely functional trademarks, are not protected. So as you may know, in the EU, we can protect shapes of products. So that's mainly those shapes that we're talking about, but are not only shapes. And it's also not an infringement to use a trademark if it's necessary to indicate the intended purpose of a product or service, in particular as accessories or spare parts. And we actually have a quite old case from the Court of Justice in the BMW and Deni case involving an independent repairer of BMWs, which had to use the trademark BMW to tell people that they could that he could repair BMWs. And the court said, yes, this is fine. It's absolutely fine to use a trademark for that purpose. So that's for IP provisions, and you can see that quite extensive and a bit patchy depending on the type of right that you're talking about. Designs is, I think, and trademarks the most extensive ones, and copyright's a bit more problematic, except software where we have the top system decision. Then we have a bunch of directives, 3 of them, main directives in the field of unfair competition and consumer protection, namely the Unfair Commercial Practices Directive, the Consumer Rights Directive, and the Consumer Sales and Guarantees Directive. So the one about sales and guarantee says that the consumer can ask for repair if there is a defect within 2 years. That might not help a lot, of course, because if your defect comes after 2 years, you basically you don't have that right. But you have a choice in the sense that you can have the product replaced, or you can have the product reduction in price, or you can terminate the contract. So that's quite a nice little thing to have as a consumer. Then the Consumer Rights Directive also says that you have a choice between repair and replacement. The Unfair Commercial Practices Directive, there's not much. The only thing which could be used for this repair issue is when you have a misleading omission. And for example, the Commission has said that if a phone battery, for example, cannot be replaced at all, or the lifetime of product is planned to be much shorter than comparable products, that's the planned obsolescence problem, then it could breach this directive, but there's no case law yet at EU level. And then I'm not going to read it, and you obviously have my slides, but there are some sectorial examples. And here, this regulation has to do with motor vehicles and trailers, and there's some repair and maintenance information for motor vehicles and agricultural machines. It is specific to specific data access and sharing obligations. So this is, very fragmented in that regard, but at least there are some laws that enable that repair to happen. Then we come to competition law, and I would agree, because I was there last week with Carl Shapiro, that on paper competition law could be great, but in practice it doesn't really work so well. Why? Because we have this wonderful Article 101 and Article 102 of the treaty on the because not even a regulation or directive, it's in the treaty on the functioning of the EU, basically outlawing cartels and abuses of dominant position. And in effect, plan of the has been actually in research, economic research has shown, at least some economic research said, that planned obsolescence only exists in monopolistic and oligopolistic markets. And we've got plenty in the tech area of these markets. You just have to think of, Apple and Microsoft, and there you go. So in effect, there is a huge role that competition law can play for these markets. I don't have to tell you about the problem of planned obsolescence with Apple and its iPhone a few years ago, where you update the software and then basically it didn't work anymore, and you couldn't revert back to the software. My husband had that problem, so I'm very familiar to that issue. Now, basically, Article 101, the problem happens if the cartel's intention is not to worsen the quality, but to reduce the lifespan, but at the same time to reduce the price. Is impossible to prove a breach of competition law. So you can reduce the quality, not reduce the quality, but just reduce the lifespan of the product. And at the same time, you reduce the price. It's not a breach in EU law. In 102, if you're dealing with a dominant player, you would say a monopolist in the US Sherman Act, I would say, then it's difficult to establish dominance. It's complex economic analysis. And basically, usually, the initiative to sue only belongs to the competition authority. Although recently that has changed, and sometimes an individual can do it, but it's very hard. So competition law is not great in that respect. Now, environmental law, and I know that Jessica is going to talk about this a lot, so I'll try to go quick on this. And Aaron, please let me know if I'm running out of time. But basically, the EU has already had a circular economy action plan since 2016 that supports durability and repairability of products. And they've issued a new plan in 2020. So, that it's been on the agenda for a while. Then there's the EcoDesign Framework Directive. It's very old. It's from 2009, if I'm not mistaken. And Jessica can slap me on the wrist if that's not right. That deals with energy labeling, availability of spare parts, access to repair and maintenance information for repairers, and it applies to certain equipment, not everything. So I let her talk about that. She told me she would talk about it. But again, you can read what I've put on the slide. And then there's the EU Eco-Label. I think that some of the speakers have already talked about this, that encourages products generating less waste, including the keynote today. I think he talked about it. And that means that makes the products more durable and repairable, because consumers can see that the product they're buying is better than other manufacturers. And then also there are standardization bodies in the EU, and they are also developing standards on efficiency, including durability and repairability. So this is the new energy label. If you can see what we have in the EU. The A is the best, and then you can also see how much basically the product consumes. I mean, we have this on different types of products, but not everything, obviously. So the measures are quite good, better than, it seems to be better than the US, and it seems also better than, to some extent, in Australia, but they don't go far enough. It's not me saying it, because they only apply it to some products, and they do not ban planned obsolescence. There's nothing against planned obsolescence. And the only, as far as my research has been done, I don't know all the EU member states laws, of course, and you have to do a lot of research to look into this, but France is the one that has now banned planned obsolescence. If it's deliberate, only if it's deliberate. So you got to prove intent, so good luck. So it's not perfect. And then they've also updated the Intellectual Property Act beyond what the EU is asking. I just put that on the slide if you're interested in what they've done. But again, what they've done in the IP Act doesn't go far enough, because it's only for certain products. You see here, it's for motor vehicles. It's not a right to repair every product. So what can we do on top of that? I mean, the EU has gone quite far, and is carry on going quite far, because they've got all these new circular economy plans, and we will see more legislation definitely in the years to come. Something that I had already advocated since 2008 for my first paper, but this is the 2009 paper here, is maybe change intellectual property laws to make them more environmentally friendly. And then I developed this to say, well, it's not just the environment that we should talk about and think about when we design intellectual property laws, because you can have a goal. You can assign any goal to intellectual property law if you want to, but they would be more focused on general well-being. So, for example, in patent law, you could say, well, the product is not just need to be new and inventive, but it also has to be better. So it's not because you've got the iPhone, I don't know the numbers, 16, 17 or whatever, it's not going to specifically be better. It's going to be new, okay, it's going to be inventive, anything that's patented in it, but it might not be better, it might be worse in effect. Sometimes that happens. So we can do that via the morality or public policy provisions, because in the EU we have them, or we can create a new way to do this within IP law. Now there's been voices saying, oh no, that's not the goal of IP law, etc. So we shouldn't do that, it should be external. Whatever way you do it, you leave it to environmental law or some other law, that's just an idea. Or if you think about the international framework, we have Article 7 and Article 8.2 of the TRIPS agreement as hooks for that. There's already in there, you cannot abuse or misuse your intellectual property right. And if you make a product that's new and inventive but not better, and you do it on purpose, or you plan its obsolescence, I think that's probably a misuse of your IP right. I mean, that's something we should think about. Now, if you want to know more about the planned obsolescence in the context of the EU, that is an absolutely great article. I thank them wholeheartedly, because I not plagiarized, but I took their ideas to make nice for my speech today, many of their ideas. And that's something I talked about already in 2009, about how manufacturers are trying to block repair and recycle. What are the provisions on repair and recycling in IP laws in the EU? It's a bit outdated because it's 2009, but not much has changed anyway, except the top system decision. And that's it. Thank you very much for your attention.
That was wonderful. Thank you so much for telling us so much about what's going on in the EU. Jessica, I think that segues pretty nicely into the environmental and eco-design issues in Europe. So why don't I turn things over to you to tell us more about that?
All right, that sounds good. Can you see my slides okay? I'm seeing some nods. Okay. Then it must be in the right form, because somehow I see it in a different form. Okay, hopefully it's displayed. Yes, that segues great into what I'm going to talk about. So Estelle very much covered the things that I do less of in terms of laws. I'm not a lawyer, but I am a policy researcher, and I've been researching policies for repair as part of policies for sustainability at the International Institute for Industrial Environmental Economics in Lund University in Sweden. So let's see, let me get to the next slide here. Yeah. So I'm going to start with something that Estelle touched upon, but also said, oh, Jessica will go more into it. And yes, indeed, the EcoDesign regulations are really a cornerstone part of right to repair in Europe. And you got the date right, 2009 is when the first framework directive comes out. And then the way that the EcoDesign directive works is it is a framework, and then you see the real details, product by product regulations pursuant to this. So each set of regulations, and they come out according to the NGOs too slowly. So maybe 4 different product groups might be coming out each year that we get then the details of what actually are the design regulations. And they've been focused, the EcoDesign regulations, on energy using products at this point. I'm going to talk about where this regulation or this directive is going as well. But for right now, looking at what we've got in the latest tranche, let's say, of regulations on things like washing machines and refrigerators, we saw that there is more on the circular economy aspects and including repair. So availability of spare parts, manuals, and also talking about that software updates must be available for as long as spare parts are available. So seeing software as part of or similar to spare parts. Repairable with common tools as well is quite interesting there. And we see one thing, I want to make sure that I'm not blocking here. Also interesting is a distinguishing between what and whom spare parts are available to. So distinguishing between spare parts that are available to any user, which would include DIY and repair cafes and community organizations, and those available to professional repairers. And here we also see that there's some now discussion about what is the line of professional here as well that needs to be defined. Also within EcoDesign regulations, we see a couple of product groups that also set minimum lifetimes for products. And this is very much limited to where it can be measured technically, because remembering these are regulations that allow products onto the market then. So they are minimum performance standards. So minimum lifetimes we have for lighting products, so that is changing recently, and also for vacuum hoses. So it's a very much a technical restriction there, and what kind of tests can you make producers do in order to demonstrate that their products are likely to meet this lifetime. So we see a discussion there, or a bottleneck in what other products these might be able to apply to. We also have voluntary policies that enable repair. So Estelle mentioned the eco labels, like the EU eco label, and eco labels themselves are voluntary, like green public procurement as well. So the criteria that that different public organizations can use for purchasing equipment, but we do see repairability requirements coming in under these as well. So availability of spare parts and manuals, maintenance information, repairable with common tools. You notice a theme here, but also longer warranties. So the street lighting, green public procurement for street lighting just came out and had all of these requirements as part of the criteria for green public procurement, but remembering that these are voluntary. But we do have also mandatory labeling. So I make this distinguishing here. Pursuant to EcoDesign regulations, there are some information requirements and some labeling requirements with that. But then we also have these eco labels, so voluntary requirements and green public procurement. On the member state level, we've heard this throughout this conference here about the repairability score in France. And it is really important, and it is going to come up again because it is so influential. It's going to be influencing what I talk about next and where policy is going in the EU as well. So repairability scores, yes, again, a mandatory label then at a member state level. So we also see here some fragmentation coming with different member states going beyond what the EU is legislating here. Also longer guarantees. So some of the member states have longer guarantees for products. Sweden, 3 years we have as minimum. Finland also has it tied to the product lifetime. France, prolonged when a product has been repaired. We also see talk of different burdens of proof. So longer than the 6 months on the consumer to prove the defect. This can be longer in some member states. We also see policies like VAT or tax reductions for repair services. We have this here in Sweden and some other member states as well as examples of this. And I want to make sure I'm not blocking here. Also then repair funds, and these actually operate in a couple of different ways. So in France, you hear France a lot. They're experimenting a lot with a lot of different sustainability policies, not only the banned obsolescence, but a lot of other things. So they have also, as part of extended producer responsibility that you pay when you're putting products on market, or you're part of a scheme. Also part of those fees, now they're asking that part of that is set aside for repairing and offering repair services or some reimbursement of repair for certain products. In Austria, we also see this as a repair bonus. And I'm going to be going also with policies, as you see, going from the EU down to the member states. But even the member states are influenced by policies even on a local level. So I mentioned about this repair bonus in Austria, which is very much also driven by what was happening in Austria on very local level, with municipalities actually having sponsoring and subsidizing repair vouchers, so some reimbursements for citizens in cities like Graz, where they could get back 50% up to a certain value of repair services from the city. We also see municipal-led repair organizations. So even here in Sweden, we have some municipalities that are basically running almost like repair cafes. They have repair space, and it is municipalities running this space. We also see municipalities getting involved with organizations like repair cafes, offering free or subsidized space, grants for tools, and different assistance, and also helping them out with networking and other assistance here too. So we see municipalities can also have, through their local policies, a lot of influence in enabling repair. Okay, and now I get into what's happening, some of the most exciting, but I think happening here in Europe right now. So we have this EU product policy package, or the Sustainable Products Initiative, and we have a proposal that has come out for a new eco-design, for a revamp of the eco-design from 2009. But it is also part of a policy package that goes beyond eco-design and design standards here too, where we're expanding beyond energy using products. So it's also going to be looking at textiles, furniture, lots of other products coming into the scope here. Also trying to have some complementary revamping, let's say, of directives like the battery directive. So there just was a new proposal last year on the battery directive, which is talking a lot about replaceability, and I can say that we talked about the norms in the previous section too. The European Environment Bureau also put out a report on removable, replaceable, and repairable batteries that we helped work with as well. And it really did look at what way would you formulate this, and what are we asking for with replaceable batteries? And there it was very much a coalition of repair organizations with recycling organizations, because as Kyle mentioned, there are common interests in having repairable batteries by different groups that needed repairable batteries for different reasons. So this package very much hangs together. It also talks about empowering consumers for a green transition. And here we see or words to the effect that there will be revamping of consumer protection laws and much stronger teeth for greenwashing, and being able to monitor practices and even enforce. But we haven't seen the details yet on how this is going to look like in practice. So this is a proposal that just came out March 30th. So a lot of us are still reading through and interpreting these details. I'm going to look right now a little more at the EcoDesign working plan and present that to give you an idea of what we're seeing proposed for this revamping of the eco-design from 2009. And we see that the Commission is proposing a lot of eco-design requirements within the scope here, including durability, reliability, reusability, upgradability, repairability, possibility of maintenance and refurbishment, among others. Before, it really was more about the energy and energy efficiency and quality requirements were the kind of two parameters that we saw. Now we see that this is going to be much more in scope here. We also have information requirements. So the digital product passports are being talked about in the EU and what kinds of information will be available, but there is already indication that there will be information about the substances that are in the product. There should be information for the users, and there should be information for disassembly and enabling reuse and recycling as well. So this very much is also seeing that this could be something that enables repair. Again, we're also seeing then this repairability score come up that, you know, France is going, and it's even mentioned in the proposal here that we see member states like France going beyond the EU. So it really is something that the EU needs to discuss or to avoid fragmentation. So that when the member states are experimenting, it is pushing for the EU to look at whether there should be this requirement on the EU level. So we see now discussion of repairability scores on the EU level from this point forward. So we can expect to see some learning from France as well. Okay, but it is, I just want to mention, a very big package, many different areas covered by this. So I have only touched the surface here at this point. Last but not least, I also want to say another barrier that we see that isn't often mentioned, but I think it's a barrier perhaps also in the US, but particularly here in the EU, when we have extended producer responsibility and waste and recycling laws that grant responsibility or have responsibility only for the producers. That also means that the waste is controlled by the producers. So we also see some issues with access to waste, not only for repairing possibly repairable or even functioning waste often, but also for harvesting of spare parts for repair that might not be made available by OEMs, that this is a possible source to it. But we see that there's problems with accessing this waste by different organizations because it then is controlled by the producers. We also see that there are incentives towards recycling because there are only targets on recycling, not on reuse or repair or higher level. They're together in the recycling targets by weight. So there isn't a clear incentive that these should go towards reuse. And the way that they're handled as well. Once they're handled as waste, they're often left outside as devices and mistreated. And that also then lowers the ability for reuse and repair down the road. That said, it is in like the WE directive around electrical and electronic equipment that access should be granted for personnel from reuse centers, but it is a negotiation then on who gets to decide what is a reuse center and under what terms are they granted access. So it is increasingly happening, but it is very much up to the producer responsibility organizations to allow that access and on their terms. So I want to leave with this idea I heard in an earlier panel too about the balance. And I think we see here that the devil will be in the details as well about how the different stakeholders in this process of discussing the requirements, how they come out, what balance is struck between the different interests and the different stakeholders here. Thank you.
Thank you so much, Jessica. That was wonderful. Now that we are all EU experts, I want to turn things over to Anthony to give us the Canadian perspective on these issues. So Anthony, take it away.
Thanks so much for having me. Wonderful to be part of a panel with so many esteemed experts. And I'm currently joining you from Florence, Italy. So I apologize, my normal internet connection is not available to me. So I apologize if it's a little bit shaky, but very happy to speak to you a little bit about the Canadian perspective this evening in my case. So I just wanted to give a sort of a legislative lay of the land, where we are in Canada in terms of attempts and progress towards legislating the right to repair. And then a bit about the politics of the right to repair in Canada, both in sort of reasons for trepidation and then opportunities for progress. So as is part of the trend right now, I am going to share some slides. Let's see if this will work. All right. Is that visible to everyone? Okay, perfect. So just sort of a crash course on Canadian constitutional law. Just like the United States and other federal jurisdictions, we have a split jurisdiction over the subject matter of the right to repair. So federally, we see a lot of the core sort of legislative areas in terms of jurisdiction are affected most primarily. So IP, copyright, trademarks is all sort of exclusively within federal jurisdiction. Competition law as well, with some minor exceptions. The provinces can kind of incidentally affect competition policy. And then consumer protection law is really a kind of split jurisdiction between federal government and the provinces, depending on the subject matter. And so this really kind of has a big impact on when it comes to legislating the right to repair in Canada, which jurisdiction is going to be first to act, and what is the scope of their ability to legislate in that area. And so, often in US constitutional law, we hear this debate about, does the state have the ability to legislate, in the context of individual rights? And in Canada, I think a lot of the constitutional debate is, which level of government has the right to regulate. So it's a bit of a different landscape in that sense, but it's really important when it comes down to the politics of repair in Canada. Okay, so there have been a few attempts federally to move forward with the right to repair, and one of them goes back quite early to 2009, put forward by NDP MP Brian Massey, and that was really targeted towards the automotive industry and trying to make parts, tools, and information available to independent repairers. And this was sort of the earliest movement towards the right to repair. It died on account of concerns over intellectual property and resulted in a voluntary agreement among industry. Then in most recent years, we've seen, after a long period of dormancy, we had this decision in 2017 called Nintendo and King, which addressed TPMs. And this resulted in over $20 million in damages for a mod chip installer of a Nintendo device, and really had a chilling effect and brought to prominence the importance of TPMs and sort of the severity of the consequences for circumventing them. And after that 2017 decision, we had a 2019 review of the Copyright Act, which viewed TPMs as being a real impediment to repair. And this sort of brought forward two recent bills. So Bill C-272 and 244, which is really to provide a new exception to TPM circumvention for the purposes of repair, or diagnosing, maintaining, and repairing a product with an embedded computer program. So that's been kind of on the books now. I mean, there was one that was the first one, Bill C-272, was passed first and second reading unanimously, multi-partisan support. An election was called, and it's been put back on the books now as C-244, and appears to be receiving the same type of parliamentary support. We're also seeing another complementary bill to the old 2009 effort to sort of modernize vehicle repair in terms of empowering the Competition Bureau to ensure that spare parts, tools, and information can be provided in the context of modern computerized electronic vehicles. So a kind of modernization of that first right to repair bill. Provincially, we've seen similar sort of attempts, but perhaps more difficulty in terms of achieving any progress. So in 2019, we had Ontario was really the first mover to kind of go at its Consumer Protection Act to really compel manufacturers to provide parts, tools, and information at reasonable prices. That I spoke with the MPP, so the provincial member of parliament, Michael Coteau, about 2 weeks ago, just to get a sense of what really was the cause of that dying. And there was immense pressure from the Chamber of Commerce. There was a lot of lobbying involved. He was also an opposition MP at the time, so there was a lot of things stacked against it. But it kind of, in some ways, provided a bit of a chilling effect in terms of provinces moving forward with consumer protection reforms. Meanwhile, in the same year, Quebec went ahead with its Bill 197, which is a bit of a different approach. So it really was looking more at sustainability. It's and in terms of upholding warranties on products rather than compelling manufacturers to provide parts, tools, and information. And also imposed penalties for planned obsolescence. So a much more heavy-handed approach and an interventionist approach, which is still sort of, I guess, waiting to be sent to committee. But the latest we've heard from Guy Hulette, the member who's proposed it, is that it seems to be kind of stalled, or there's not a big willingness to move it beyond this point. Lastly, British Columbia almost sort of went ahead with a provincial proposal to amending its Consumer Protection Act, but it sort of unfortunately did not receive enough I guess, detail in its proposal. So it was really brought forward to a union of municipalities that were then proposed to the province of bill. So it's kind of a complicated legislative procedure, and unfortunately it was lacking detail. I don't know if Alice Henry might be on our call here, but can speak more to that effort. So those are the kind of 3 provincial efforts that we've seen with, I guess, mixed results in the case of Quebec. In terms of the public support for right to repair, I mean, it's overwhelmingly positive in Canada. I think that's the case in many jurisdictions who reach out and ask consumers what they think about it. 75% of Canadians support it. It was part of the Liberal Party of Canada's platform when they were re-elected just last year. And they've since, I guess, directed ministers involved to take legislative action towards the right to repair in terms of competition and IP policy. So there seems to be progress in terms of political appetite to take this on. And finally, the Innovation, Science and Economic Development Canada, ISED, who's in charge of sort of driving our IP policy, is sort of looking into, particularly on TPMs, what are the real impediments to repair? How do we classify TPMs? How do they, in practice, impede repair? So they've been sort of zeroing in on the TPM aspects of that. And then in terms of trepidation, there's sort of a few different reasons why we see policymakers, showing some hesitation to go ahead cavalier towards the right to repair. And the first, I guess, is this sort of chicken and the egg when it comes to consumer protection and IP policy. So who is to move first? And you see this a lot when we speak to policymakers about, why don't provinces move quicker towards amending consumer protection acts? And they say, well, we don't want to interfere with what we need first, a sort of license from the federal government in terms of an open field for IP policy. And so going back to 2009, that was kind of the reason for that bill not making it through. The second is the federal government being, concerned that it's overstepping its jurisdiction with respect to consumer protection. And so going back to that old fight between the provinces and the federal government, whether or not the federal government wants to sort of overstep its jurisdiction and to take a heavy hand with consumer protection regulation. Third, of course, and no small feat, is the effect of lobbying. Now, we've only seen this one heavy-handed approach back in 2019 in Ontario, but we can expect to see more of it when these federal bills that are being proposed make it to committee. And finally, CUSMA, the Canada-US-Mexico Free Trade Agreement, or NAFTA 2.0, has a reiteration of very strong protection for technological protection measures, and enacts criminal penalties for their circumvention, which is a new thing that we have yet to legislate. There are some exceptions. There's some grounds for enacting new exceptions in Canada, but it's sort of a technical policy matter that if you speak to private members about their willingness to propose new exceptions, you frequently see a kind of paralysis that comes up, because when you involve international trade in the context of kind of grassroots political movements, there tends to be a kind of hesitation to take on a fight with that level of implication. And so some unrealized opportunities, there's a lot of room for federal competition law reforms. So, I mean, there's plenty of room to enact new offenses under the Competition Act, to treat restrictions on repair as anti-competitive, whether that be through abuse of dominance or the essential facilities doctrine. There's also plenty of room for the federal government to enact a federal repairability rating, similar to the French system. That would be within its jurisdiction and align with a lot of other kind of schemes that the federal government is in charge of in terms of product labeling and product standards. There's a lot of ground to look at the Trademarks Act here and look at spare parts, the implication for counterfeit goods provisions of that act, and how they might impede the availability of distribution and refurbishing of spare parts. And I think, lastly, what we really need to see is more consistency in provincial consumer protection reforms. So sort of a common approach. What we've seen between Ontario and Quebec so far was, two very different approaches, right? Like, Ontario was very much looking at how do we mandate manufacturers to provide parts, tools, and information, and Quebec is saying, how do we deal with warranties, product lifespan, and planned obsolescence, which is a very different sort of perspective, right? So some sort of coherent provincial consumer protection strategy is definitely needed across the country. And I just wanted to finish with kind of a, I guess, just a comment on the political economy of Canada. And that is, Canada is very much an urban and rural divide of a country, if you will. There's the politics of Canada is shaped by this, and most of Canada, lives in a very narrow part of the country. Yet it is a very rural country. And so I think if I were to make any plea to Canadian advocates for the right to repair, is that beyond the consumer protection or the environmental arguments for repair, we should also look at it as an issue of nation building. And that repair being something that can empower remote and rural communities to be self-sufficient, to have the kind of economic self-sufficiency in an increasingly technologically driven economy. So I think that's my sort of final call, is that we maybe look at repair as being something uniquely Canadian and part of an ongoing process of nation building. Thanks very much.
Thank you, Anthony. That was wonderful. I know that we all have a lot of questions that we would love to ask this final panel today, but being mindful of the time, I think I'm going to thank them for sharing their expertise with us. And that goes not only for this current panel, but for all of the folks who joined us in this conversation today and last week. We've benefited. I know I certainly have benefited immensely from their insights.